Speaker of Parliament Alban Bagbin took aim at the judgment of the Supreme Court that stayed its ruling on those 4 seats. He asked his lawyers to file an application to get that set aside. But even before that argument will be had in court, his lawyer was on his feet in opposition to one member of the panel, Justice Yao Enes-Gayeu.
He was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings.
said no. I think you said enough. Kindly resume this.
Very well, Malik.
After listening to the arguments on both sides, the Supreme Court, the 5-member panel, did not agree with Thaddeus Sori, lawyer for the Speaker, that Justice Yao Enes-Gayeu should recuse himself from the case.
This court must take judicial notice of the fact that within the ranks of the Superior Court is a former member of Parliament for the National Democratic Congress, a former General Secretary of the People's National Convention. The subject matter of this suit before this court is a constitutional dispute and not a matter involving political parties. The objection is therefore misconceived. Move your application.
The court then zoomed into hearing the substantive case. It first heard from Thaddeus Sori, who raised a litany of issues with the judgment of the Supreme Court, which he said should convince the same court to vacate that earlier ruling.
The writ or the processes on the basis of which the court's jurisdiction was invoked for the order are void because they were filed in violation of the rules of the court. That irregularity is incurable. That even if it were curable, which it is not, the court's jurisdiction, substantive jurisdiction, to entertain the matter as a whole was not properly invoked.
The Attorney General himself actually did come in and raise some points of law which he said simply made the case of the Speaker of Parliament untenable.
Whenever a decision of a court is being sought to be reviewed, varied or discharged, the procedure for doing so is as set out in the Constitution. And this is not an invocation of any of those procedures.
After hearing these arguments in court, the 5-member panel unanimously dismissed the position that was canvassed in court by the Speaker of Parliament and his lawyers.
We have considered the application and find that the grounds supporting the application have no merit because of the very explicit and clear directions of the 1992 Constitution, specifically Article 2, Article 130, and Article 296, and established decisions of the Supreme Court from decades of the country's constitutional history.
The court has now adjourned to 11th November to hear this case again, and the expectation is that on the same day, the court will hand down its judgment on the interpretation of Article 97, 1G and H, which talks about whether or not if a member of Parliament decides to contest as an independent for the next election, he vacates his seat, and also whether or not an independent member of Parliament who decides to join another political party and contest on the ticket of that party for the next Parliament also loses his seat. Reporting for Joy News, Kweku Asante, Supreme Court, Accra.
Judge starts speaking, you stop. Do you not appreciate that?
Oh, my lady, I don't think my lord thought I interrupted.
So the question is, from the courtroom, where do we go from here? Especially after the Apex Court tore into the Speaker's decision to declare 4 seats vacant, arguing that his decision had serious implications for the thousands of Ghanaians who lined up to vote for these parliamentarians. The reason for which the Supreme Court was constitutionally clothed with the power to make pronouncements on the matter, though it has not pronounced on that substantive matter yet. We delve into the matters arising with our guests this morning. We have Kweku Paintel, he's a lawyer. We have Inusa Fusaini, also a lawyer. He is a former legislator for Tamale Central. He joins the conversation, and former minister as well. He joins the conversation. Inusa Fusaini, let me just start with you to be sure you are here with us. Can you hear me, sir?
I can hear you. How are you?
I'm well. I hope you are too.
I'm fine.
All right. A very good morning to you, Mr. Paintel, Kweku Paintel. At least you are fortunate to be in the studio, so a line will not drop this morning. Okay. So, Inusa, just hold for me. I want to start with Kweku Paintel and get him to share his thoughts on the happenings of yesterday and what you made of the court's proceedings as far as the petition by the Speaker of Parliament and the ruling of the court. And I want you to add, I want both of you gentlemen, there seems to be a trend. Some people say that the Chief Justice is a bit too boisterous, and some even suggest disrespectful sometimes. But if you know what happens in court, you know that sometimes it can get pretty rancorous. But where do you sit on these two quick points before we proceed?
The boisterousness of the CJ, or which one are you talking about?
Both of them, whichever one you
I'll
want to
put it this way. I mean, there are comments I'd rather not make. In other words,
I know it's an uncomfortable territory for all of us, but
I've ever made some comments about some lady in very formal proceedings where it was taken not to be too kind for women.
Okay.
Because there can always be an interpretation given to some of these things. But I would say that from my own experience, judges generally, they differ so much in attitude and everything. So the constant theme every time that I talk to my juniors is take a judge for what he is. Never make an assumption about any judge. Some judges are so calm, some judges are boisterous, some are prone to anger and all kinds of things that you can never compare two judges and claim that they are the same in any way. Yes, so that's the way I will take it. I mean, that's from my own observation at the bar. Never, ever. It's a very dangerous thing to think that every judge will behave the same. Right. But the important point is about the law. At the end of the day, it's the law that we all go to court for. The form in which justice may appear to be dispensed may make somebody uncomfortable. A judge can make you uncomfortable and still get a judgment in your favor. And so those judgments will be left to be shared on some other platform. But we are here speaking matters of law, and I'd rather concentrate on matters of...
So that brings me to the other point I asked you to reflect on. Basic view of what happened yesterday, brief one, because we're not getting into the meat of it yet.
You're right. For anybody who has been listening to me on this subject, at least even in this studio, I personally was not really surprised by what happened. It's something that I had indicated and stated over and over to be the clear position of the law, except that every time I've made that statement, I'm a little careful to state that my view may not be taken to represent the state of the law, because it always takes a court of law to make a ruling. And whether you agree or not is a different matter. But based on what happened yesterday, it's like the kind of predictions that I myself had made with regard to the substantive matter that is before the court. And indeed, if you allow me to make a comment too early in the day, it exposes the contradictions, in my view, that exist in the Speaker's position from day one up to yesterday.
Okay, we'll get into those points, but briefly, just a quick thought. Again, and I know Inusa is in the wings waiting to get his thoughts across. Clarify for me. You have 97(1)G and H. If they don't kick in when the act is committed, and they are supposed to kick in after the fact, post facto, right?
Yes.
Which may be in the next parliament. What is the effect of the law?
No, when you talk about kick...
Then it makes the law redundant, doesn't it?
It's based on interpretation. You know, the question that you're asking assumes, for instance, that your interpretation of the effect of those two clauses are what the Speaker, for instance, thinks, which I fundamentally disagree.
No, I am merely thinking as an individual that if this is what the law says, and we say that it must only take effect from the next parliament, for example, right? Someone may not make it to the next parliament, then that matter is resolved on its own. If the person does make it, there are no punitive measures in the first place. So does that not make those clauses moot? It makes them moot, doesn't it?
It can be moot only on the basis of the assumption.
Okay, all right. So let's hold it there. Let's bring in Inusef Husseini. You have different things to look at. Your basic view of what happened yesterday before Sweetie starts ushering us into the key points, the decisions that were made.
So I'm going to start from where you started with Mr. Kuku.
With what?
So the courts are not tainted by the boisterousness or condescending nature of judges.
Could you repeat that for me? Could you just speak up? Repeat that for me, please.
The court is not tainted. The court is not tainted by the boisterousness of a judge.
Okay.
Or the condescending nature of the judge.
Okay.
What the court should be concerned with, and what individuals are interested in knowing of judges, whether they exude the law, they speak the law, whether they take facts into consideration in arriving at their decisions. What evidence are they making their decisions on? That's what individuals. So a person, the idiosyncrasies of the judge cannot be the law.
All right.
Now the second thing is, my view is, the Supreme Court is becoming too inconsistent for my liking. It is not for nothing that the Supreme Court is the apex court of the land. So their decisions are binding on all other courts. And so when the Supreme Court gives decisions which appear to be inconsistent, it erodes the basic principle of democracy, that is the rule of law. And simply put, the rule of law simply says that individuals, citizens of a country, must be able to predict the consequences of their actions or decisions with reasonable certainty. That's the rule of law. So predictability and certainty are cardinal in a democratic setting.
Are you saying that the predictability of the court's decisions, of course, there could be precedent, there could also be a departure from past decisions, but are you saying that the predictability of the judicial system is being watered down, is being taken away?
Yes, it's being watered down. It's being chipped away gradually. Gradually. And I can give you an example. And that's why when the decision of the Supreme Court, and there has been long-standing decisions of the Supreme Court that have said that when a person is elected into Parliament, it's prima facie that the election is right until set aside. That person is validly elected into Parliament until that decision is set aside. Now, the election is nullified. Now, when the Supreme Court makes a decision that way, one will say that the Supreme Court is holding the principle of representation very high. It's giving vent to Article 97 that prioritizes representation. And when the Supreme Court backtracks and says that somebody should be restrained from attending Parliament by reason of abdication of a dispute in court,
right?
Then it introduces inconsistency. And then you have the very Supreme Court that prides the place of representation in our democratic setup, refusing, failing, or neglecting to settle the issue of Central Fee, Akpafo, Lolobi, and Lipe expeditiously. And then the Supreme Court gives as justification the reason why they are staying the execution or issuing temporary measures to prevent the execution of the or expulsion of the 4 rogue MPs from Parliament,
Right.
and then they cite representation. So how do you reconcile that?
Okay, so
That is my
fundamentally
worry.
what you're saying is you disagree with the ruling.
No, I disagree. No, that's a different. We are coming to that. I disagree entirely with the ruling to say the execution of the ruling of Backwood. Entirely. And I make no apologies. Entirely. The Supreme Court had no business
All right.
in the execution.
Okay,
The Supreme Court's jurisdiction is circumscribed by the Constitution.
All right,
And they refer to it when they were giving their ruling.
All right, Inusa, we'll get into the substantive case. Sweetie, we'll start with Kweku Paintil in the studio. But you've made mention of something that brings me to a point. Thaddeus Sori yesterday made a point about the fact that Justice Gayu, had some political tainting, and that because of that, because he had contested on the ticket of the MPP or had wanted to become a member of Parliament, that made him unfit to sit on the case, that specific case. And mention was made that there's a judge from the CPP stock and another one from the NDC stock in the past. Is it a problem if on political issues there is a judge who is sitting who also has shown in the past some leanings towards a political party? Is it a problem? Just give me a brief response on that.
It's a problem. It's a problem because it leads to a perception that justice will manifestly not be seen to have been done.
I see. Okay, thank you. Thank you for that response. Sweetie,
over
to you. I don't know whether you want to talk about that.
Not yet, but something you said, Mr. Paintil, that the Supreme Court has the right to interpret the Constitution whether you agree or not, right? You said that. Right. But the substantive issue is whether or not that was the right platform to seek interpretation or to, send your concerns to. It was supposed to be the High Court. So does it matter that they are using the Supreme Court rather than the High Court, which the Constitution has made provision for?
The practice has always been that when the Supreme Court shares concurrent jurisdiction, or even concurrent advisedly, in other words, where there's power to go to the High Court or go to the Supreme Court, there have been cases where you can go to the High Court, but the Supreme Court is the supreme on the land, because I know the provision
the Constitution specifically made provision for this.
Yes.
Meanwhile, we jumped that, and we are the Supreme Court now. Does it not matter?
It does not matter for the reason that in the instant case in which we find ourselves, the going to court was consequent upon the Speaker's specific conduct. In other words, the Speaker has made a pronouncement which essentially sought to disqualify 4 MPs from Parliament. In doing what he did, the Speaker sought to interpret the Constitution even though he claimed that what he did did not amount to interpretation, and that it fell within his competence even to make the pronouncement without he appearing or being seen to interpret the Constitution, which is something that I fundamentally disagree. And therefore, in the particular context that we find ourselves, where the matter before the court was to seek for an interpretation. See, if you go to the article that you mentioned in the rules that give the High Court jurisdiction, it's a case where you go to the court as a substantive matter. In the substantive matter, the facts are there, and then you go to court, invoke the High Court jurisdiction. In the instant case, it's an interpretation of what was happening in the light of the Speaker's conduct to oust these 4 MPs from Parliament. And the Supreme Court was being called upon because in doing what he did, the Supreme Court sought to interpret. He may not have used the language, interpretation, but essentially what he did amounted to an interpretation of the article of the Constitution, which he claimed was not an interpretation, my understanding of what the Speaker did was that anything that he did within the context of what he did, even though it involved his appreciation of that constitutional provision, did not amount to an interpretation, which in my view is dead wrong, insofar as he sought to rely. And he quoted those specific provisions of the Constitution in what he did.
So now the Supreme Court has tore into the Speaker's ruling.
That is so.
Do you agree with the outcome of yesterday's sitting?
I wholly and wholeheartedly agree with the view that...
We just heard Inisa Hussaini says he disagrees.
No, you see...
What's your argument?
No, with respect to Inisa, if we're lawyers, you disagree. You know, see his starting point. He's talking about inconsistencies with Supreme Court, whatever. Could the inconsistency be the basis for disagreeing with what the Supreme Court did yesterday? Because this sort thing that he talked about, the facts, the court are supposed to be consistent, but let the facts and the evidence be the same. It is only within those contexts that you can say that the Supreme Court is not being fair and so forth and so on. Nobody is denying anybody in this country a right to be represented in Parliament. The Supreme Court specifically, in making an issue about the urgency of this matter, refers to the peculiar circumstances of this case, being the fact that these were MPs who have sat in Parliament for 4 years and they've got 2 months to end their term of office, and within those 2 months, somebody has made an interpretation that suggests that they should no longer be there. It is within that particular context. If you look at the facts and the evidence in the Saul case, they never even had a parliamentarian to begin with. Nobody really is claiming that they are not entitled to representation in Parliament. But in fairness and with due respect, if you compare the facts and the evidence, they don't raise the same issue as the Supreme Court said. You may say they are inconsistent, but what are the facts? What is the evidence in support of those allegations? So in my honest view, unless my good friend is coming up with the substantive reasons why he thinks the Supreme Court erred on the peculiar facts of this case, the facts are never the same. The facts and the evidence are never the same. That's my honest view about it. But I'm sure you have an opportunity to respond.
Yes, he will have an opportunity to respond. In fact, let's go to him right away. Mr. Inisa Hussaini, so make your argument now. Mr. Pencil is saying that he's 100% in agreement with the outcomes from the court yesterday. And you are saying that's because of the inconsistencies and, you know, issue. What is your argument, really? Let's hear you out. So
first of all, one must know that the Supreme Court's jurisdiction is constitutional. The Supreme Court's jurisdiction is not at large. So all of us know, including Mr. Pencil, that the Supreme Court has no speculative jurisdiction. I listened and read the ruling of the Supreme Court when they stayed the execution of the ruling or order of Mr. Speaker, declaring the seats vacant. They gave basically 3 reasons. One was that government business would be affected. Mr. Pencil says you must look at the facts. So what facts were before the court that led the court into arrival at a decision that government business will be affected? That's the first one. The second one, what they said, was the fact that the people were not given a hearing. I said, Mr. Supreme Court, you are looking at Article 97. Article 97C, 1C should guide you. Because where the drafters of the Constitution intended that natural justice rule will apply, they provided it in the Constitution, in the same article. So when a member of Parliament absents himself for 15 sitting days without the written permission of the Speaker and with a reasonable explanation to the Committee on Privileges, his seat is declared vacant. So when you read it, you'll be left in no doubt that the drafters of the law intended that natural justice rules will apply. Then they talked about a representation. Yes, so he's talking about the fact. But what is the outcome? I'm looking at the outcome. You are looking at representation. I didn't say that somebody's facts are different from another person's facts, or they are the same. But I'm saying that if a constitution prizes representation, consistency is very important in ensuring that we send a clear message to the people of this country that this is what we mean by representation. 3, Mr. Kuku Pencil, the Supreme Court's jurisdiction to interpret the Constitution is a jurisdiction given to them by us, we the people of this country, in exercise of our inalienable right established those institutions and gave them specific mandates. Their mandates are not at large. And so, if the Supreme Court is interpreting the Constitution, I have absolutely no problem. But Mr. Pencil, you say nobody should pretend to be interpreting the Constitution. As a lawyer, on a daily basis, you interpret the Constitution to guide your affairs based on your understanding of the provisions. But that doesn't make your interpretation authoritative, binding, and final. What the Supreme Court does is a final, binding, authoritative interpretation. So when in 1998 or thereabouts, when J.H. Mensah went to court and sought an interpretation of the provisions, particularly Article 78, and whether the newly elected government had a duty to have the ministers it was appointing vetted, the court said yes, because the tenure of office of the minister and the president are coterminous, and since the president's tenure of office was over, the ministers appointed thereafter, after winning a re-election, ought to go through vetting. That was a binding, authoritative interpretation, and we all followed.
Right.
We all followed.
So looking at
that is what we are saying. So we are saying that nobody is disputing the power and jurisdiction of the courts to interpret the Constitution. But the courts have no jurisdiction where another creature of government, an arm of government, is performing its duties consistent with the Constitution and the standing orders, particularly Parliament. It is the Constitution that says in Article 97 that the Speaker declares those things vacant. He didn't invite or invoke any other provision. He invoked that provision. Granted that his invocation of that provision does not speak to what Article 97, 1, G and H means.
Right.
It is the Supreme Court that will settle it. There's no problem. Now, the fact that, and you raise the question, it is under Article 99, I think 99.4 or so, that says that the High Court shall have the power to declare whether a person has been validly elected or a seat has become vacant. That is not mutually inconsistent. Specifically on the member of Parliament, specifically on the member, so that's a specific jurisdiction given to the High Court to determine whether or not a person has been specifically or eligibly elected or the person's seat has become vacant. The jurisdiction that they sought to invoke is an interpretative jurisdiction, and that binds everybody in this country.
Okay, thank you. Hold for me.
So it is totally wrong to suggest that nobody interprets the Constitution except the Supreme Court.
All right.
Everybody interprets the Constitution on a daily basis, except that where there is a conflict in the interpretation. It is only the Supreme Court that has a final, binding, and authoritative interpretation on the provision.
All right, thank you. Mr. Hussein, hold for me. So, Mr. Pensa, I'll give you the chance to respond. So he's saying that no one is challenging the powers of the Supreme Court, but it just appears that they are interfering in parliamentary business in this case.
There's a contradiction even what he said. In the first place, you are suggesting to us that when the Speaker sits to purport to interpret the Constitution, it is his jurisdiction to do that. I say no. I agree that everybody has his interpretation of basically everything, not only of the Constitution. But when anybody sits in whatever capacity to purport to interpret or to do anything that suggests that he's giving a meaning to a constitutional clause, in the instant case, in the provisions that we have mentioned, that is what the Speaker sought to do. The sole issue...
Mr. Pencil,
yes.
These 4 members of Parliament
yes.
have filed
yes.
with the Electoral Commission, and they were still in Parliament.
Yes.
I asked you this question the last time we had this conversation.
Yes.
Who did it really fall to ensure that they got out?
No, that's what I disagree. That's
so
nothing.
They shouldn't have. They should
no,
just stay there to the end of the term.
No, it's an attempt to interpret their conduct in relation to those 2 clauses. And please, because the Supreme Court is going to rule on that matter, all that I have done so far is to give my understanding of these same 2 constitutional provisions that you are mentioning. And please, you can mark me out, because the last time I did a wager with Amanda on this matter, as to what interpretation Supreme Court is going to give to those two provisions. And it is my view of the matter that the interpretation that other people seek to give to those two clauses to suggest that an intention to contest the election, not on the ticket of how he came into Parliament, amounts to abdication, amounts to a departure, amounts to whatever other than being a member of Parliament is, in my honest view, very wrong. And please, this matter will be resolved only when the Supreme Court gives its interpretation of the same two clauses. I'm so convinced, in my view, I may be wrong.
Okay.
But then let the Supreme Court rule, because when the Supreme Court rules on that matter, it resolves all of these arguments. And the country, at least on party lines now, let me put it this way, is divided over that issue. It appears that every member of a parliament who belongs to the NDC thinks that those two clauses ought to be interpreted in a particular way. It appears that everybody in the NPP also thinks otherwise. I sit here not as a member of any of these parties, but as a lawyer with my own understanding of the same constitution. I may be wrong. But once I've stated my view, I can't make it clearer than the way I've put it. And I would rather hold on for the Supreme Court to rule on that matter. And when the Supreme Court rules, we'll all be bound by it. My view of the matter clearly is that any other interpretation that is put on those two clauses to suggest that by giving an intention to leave Parliament.
That's where I have a challenge. You call it an intention, but it's not an intention.
Let me
They
clarify.
actually took a step. There was an action to register, to
clarify.
forward.
Isiama in Fomena
Yes.
is not expressing an intention. He came to Parliament as an independent candidate.
Yes.
On the back of that, because of what his position meant to the MPP,
Yes.
he became second deputy speaker.
Yes.
He has not just shown his intention, he is on the ballot contesting on the ticket of the MPP. What intention are you talking of?
I'm talking of intention to mean that the picking of nomination during the course of time of Parliament does not stop you from remaining on the seat or the color on which you came into Parliament. That intention is expressed now to mean that it is only after elections. You see, the impression that is being given that if, for instance, I'm a member of NDC and I said that next elections I'm not going to stand on the ticket of NDC, that suggests that I have parted ways during the term. It's wrong. It's only in Ghana, with due respect, that we think so. The impression is being given that once you give an intention not to stand on that or not to belong to that party in the next elections, it means that you have severed your relationship. Is, in my view, dead wrong. Because I tell you that on everyday basis, when you are working at Joy, if next year you want to work with Peace FM, come on, all you do is to give notice and give the notice. Some people consider that analogy as inappropriate, but let them reserve it to themselves. And I've told you that those are the two examples because they are everyday occurrences. I mean,
but you see, I've always had a problem with that bit about notice because there are different terms, and someone could say, I've seen an example of someone giving a notice, and the employer said, you know what, I don't want to work with you anymore. So you might as well go ahead.
I do it all the time.
And so you do it all the time.
Because
exactly.
I'm a Ghanaian. You see, the Ghanaian attitude is that you can't give me a notice to say you don't be working with me in 3 months' time, and I'll permit you.
So just clarify for me. I want to go to Inusa. I want to go to Inusa on a certain point and come back to you.
Yes.
What you're saying is that let's assume someone becomes a member of Parliament. Yes, in the 9th Parliament.
Yes.
The Parliament to come, right? He contested on the ticket of the NDC, becomes a member of Parliament, and maybe let's assume there's such a narrow, or even evenness in Parliament one more time, okay? And this person came on the ticket of the NDC, and within a month or so says, you know what? I no longer want to be with the NDC, though this and that. I want to be with the MPP.
Yes.
After a month, okay? What happens to such a person? Will that person technically, per the law, per this same reasoning, what happens then to that person and that seat? How will it work in Parliament?
The law comes into being only upon certain steps being taken, not the declaration of intent. In the first place, that party will rid itself of that candidate by dismissing.
Because you talk of intent. In
Yes.
this instance, they have gone ahead to take certain actions. You still stick with intent.
That's
so I'm saying that in this instance, it will still be intent, right?
Yeah.
But the person would have actually taken the move. The speaker, there are processes that will be triggered. The speaker then has to. What do you think happens in such an instance?
No, for that intent to be actualized, one of two things will have to happen. The party against whom this person is playing that game can just go ahead and dismiss him. If it dismisses, it effectively terminates the relationship, and that will bring the matter to an end. For an honorable person, he himself can resign. And if he does the resignation, of course, it puts him out of parliament. But if those, either side, nobody's invoking these clear provisions, and they want to permit him to sit there, it's their own game.
And that is why it's become interesting, because of the 4 people, the 1 NDC MP and the 3 others, none of them have actually taken the matter to court themselves. So we are dealing with this matter. No, I'm just saying that that's the interesting part. None of them decided to go to court, but it's become a tussle. Yunus of Hussein, I just want you to clarify 2 things for me. Did you say this for our viewers? I want you to clarify, and then we'll move on. 1, did you say that the courts have no jurisdiction over another arm of government, especially Parliament? Did you say that?
I said that.
You said that?
I said that.
Okay, the courts have no jurisdiction.
Their jurisdiction is a general jurisdiction. It's a general jurisdiction and invokes or comes into play in that interpretative capacity.
Okay, all right. Thank you.
In an interpretative capacity. It's a general jurisdiction. To suggest that the courts can outreach the decisions of the Parliament is to circumscribe Parliament, subvert Parliament to the whims and caprices of the court, and it is not consistent with the rule of law, neither is it consistent with the separation of powers principle.
Thank you for that clarity. Did you also say it is wrong to say only the courts have power to interpret the Constitution?
It is wrong to say that. Only the court has the power to interpret. It's wrong to say that, because on a daily basis, you and I interpret the Constitution. But where there is no clarity or certainty in the interpretation placed on the provisions of the Constitution, we, the people of this country, have decided that it is only the Supreme Court that can give a final authoritative interpretation. That is why when you go to a lower court and there is no conflict on the provision, the lower court enforces the provisions of the Constitution. By enforcing, they have to understand what the provision means to be able to enforce. But the lower courts do not have the jurisdiction to interpret the Constitution, but they must enforce it based on their understanding. And if they understand it in a certain way and enforce it, and you believe and feel that their understanding is contorted, is twisted, and it's not in consonance with the Constitution, you escalate your matter to the Supreme Court for interpretation. In fact, the courts have even developed a practice where when you go to court and mark an interpretative action as a suit, as a writ, the court will stay the writ and escalate your matter to the Supreme Court for interpretation, because it is only the Supreme Court that has the power under Article 130 to make a binding, final, authoritative interpretation. That's what
I'll come to what...
I'm coming.
All right.
Mr. Pencil talks about intention. You see, even in your studio, intention, the meaning of intention has been brought under the microscope. Don't you see it? Then he says, well, you must take certain steps, concrete. But he forgets Article 50 of the Constitution, 54, where a candidate files for an election and dies within 25 days to an election. The Constitution says what? That candidate or his party is given 10 days for a replacement. That should give you an indication that rights have accrued. The right of the candidate to partake in the election has accrued. And that's why the Constitution is bending backward to accommodate that person.
On the bit, we have limited time. On the bit of predictability, I don't know whether you got the NDC MPP scenario I just painted. Someone who goes into the next parliament and maybe after a month or 2 decides refusing to resign, but decides to join or caucus with the other side and says, in the next election, I'm not running on the ticket of this party. In terms of the predictability you spoke of, what does this do in the legal sense to some of these, problems that could arise?
The democracy becomes solid, concretized when it's stable. So when you are reading the provision, you must read it to understand that we are looking for stability in our democratic practice. And so when you allow flexibility of movement, and it is totally wrong for people to say that everywhere in Britain, when 4 members of parliament of the Conservative Party rose against the decision of the previous prime minister, they were expelled from the party and the by-election had to be held. Mind you, the member of parliament's position is a party position. It is incongruous for you to lose your membership of your party and continue to represent the party in parliament.
Okay.
It's incongruous.
Let me come to Kweku Painter.
No, but let him answer the question. Why did the NDC not dismiss their members? He's talking about 4 MPs.
Why did the MPP not dismiss?
Both parties. Both parties. Because that's what has brought the constitutional issue. That's what has brought the constitutional issue. Because he acknowledges that.
I don't want us to get stuck on that point.
Thank you very much.
Kweku Ansah, this will be my final point. Former director of the Ghana School of Law, Kweku Ansah. He has criticized the Supreme Court, the apex court, and he says, I just want to go through a bit of what he says. He explains that the court's jurisdiction was not properly invoked when the Speaker made the ruling declaring the seats vacant. He says, the ruling is yet another example of our current Supreme Court living up to its accolade as an all-too predictable court. Their jurisdiction was not properly invoked, and today the Chief Justice has been heard saying that the jurisdiction of the Supreme Court was invoked when the Speaker made the ruling. Let me correct that erroneous impression. The jurisdiction of the Supreme Court can never be invoked after the Speaker has made a ruling in the chamber. The Supreme Court's long arms do not reach out to the Chamber of Parliament, and therefore whatever the Speaker says on the floor will never constitute a proper invocation of the Supreme Court. It goes on and on. Your take. That's what I'll leave you with.
One, I don't agree with him. He is seeking to suggest, for instance, that if in the Chamber of Parliament the Speaker exercises a right or authority to do something which is manifestly illegal, then by reason only of the fact that he did in the Chamber of Parliament, Ghanaians must sit and look over it. It can never be a reasonable interpretation of any portion of our Constitution. And I fundamentally disagree. And please, I'm saying, in about a week or 2 time, the Supreme Court will have the opportunity to express its own view on this matter and to bind all of us. We may continue to debate this matter long after the Supreme Court has even ruled.
Which is itself not perfect, and its decision
obviously,
also very imperfect.
I made the point that the idea that the Supreme Court or any judge for that matter has all the wisdom, it can never be the case.
Okay.
Yes, it can never be the case, but we are bound to follow their decisions unless set aside. And personally, I consider everything that ran up to yesterday as so much inconsistent. We have a speaker who had received an order that he himself failed to agree with, but on the day he sat in Parliament and made a ruling, he acknowledged this order. Then in the next moment, he sent the order back to the court on the basis that it was not properly served on him. Then he went ahead in the Supreme Court to found an application on the very order that he claims to not have been properly served on him. This is inconsistency, and it exposes an agenda, which is that somehow Parliament must hang as things stand now. And that's my own view of the matter. And that's why I think that once the Supreme Court rule, will come back to everything that we have said, and then those who disagree with it will continue their narrative. Those who agree will continue to stand where we all are. But for now, let's not forget that we are all debating a matter which is yet to be manifested possibly in about 2 weeks' time, when the Supreme Court finally sits and makes its ruling. All I'm doing or have done so far is to make, at best, a prediction as to how, in my view, this matter would end in the Supreme Court.
We do have to go. We don't have any more time for questions, but I want to leave us with this. I mean, the country is divided over this matter, some siding with Parliament and the Speaker, others with the Supreme Court and all that. This is something from Senyor Husi, and he says, Mr. Speaker, following the dismissal of your motion to have the Supreme Court vacate its orders in the Apenyo Makin versus the Speaker case, there are many expecting that you will ignore the apex court and proceed in an assertive fashion. Well, you may do that, perhaps with limited consequences for your person, as the rest of us would have faced if we disobey the Supreme Court. But that may be the high crime. I wanted to ask, what would be the high crime? But we don't have time enough for that. Those who join us for this conversation, Mr. Painstill is a lawyer.
Oh, I thought you were calling me to give a final remark.
Well, in about 30 seconds, do that for us, if you can.
So my final remarks are simple today. We are waiting the Supreme Court to give its interpretation to the jurisdiction. We disagree with the state of execution because the state of execution is like a subsidiary legislation. It must be founded on the Parent Act. Where the writ said to, the writ invoking the jurisdiction of the Supreme Court, filed by Apenyo Makin, spoke nothing about a decision of the court.
All right, Mr. Hussein, unfortunately, we have to go. That's all that time will allow. Thank you so much for joining us. We also have Mr. Kweku Painstill in the studio with us. He's a lawyer. And, of course, Benjamin Akakpo and I are here steering the conversations for you. We'll be back in a bit with more on the AM show.